Your Honor, I guess first and foremost, I need to renew my motion, and the court didn't rule on it, I don't believe. The motion to dismiss the disinterested parties. Based on the testimony presented today, there really is only one real party in interest, and that's Plaintiff Bracey. You heard Plaintiff Arellano speak today. He didn't make a formal written request. He wasn't involved, at least in name, in any of the following correspondence after that public record request was made. He's not an interested party, Your Honor. Even more so, the other the other 6 individuals, including Mr. Rojas, who just testified, there's been nothing alleged that they've had absolutely no contact with the county in making the records request. They indicated, at least Mr. Rojas and Mr. Arellano indicated that individuals on their behalf were making the request, but the nature of that relationship was not identified and certainly isn't legal. There was no power of attorney. There was no attorney-client relationship. As previously addressed by counsel, Audit Arizona isn't even an organized entity that would have a board of directors or executive officers, statutory agents, etc. There's no nexus, Your Honor, between the nominal plaintiffs, and that's what I'm going to call them, the nominal natural person plaintiffs and the defendants, with the exception, again, of Plaintiff Bracey, who wrote the letter, who verified the complaint that brought us into court today, and who had the additional correspondence. He's the only one, Your Honor, and everybody else, all the additional plaintiffs just have no involvement under Rule 17A, Your Honor, and I'd ask that they be dismissed under Rule 12B6.
Be dismissed under
Rule 17A of the Arizona Rules of Civil Procedure, as well as Rule 12B6 of the Arizona Rules of Civil Procedure.
Your Honor, the Arizona Public Records Statutes do not prescribe any set form by which a citizen must make a records request. It's very open-ended the way the citizen may do it. I don't know where the state is getting this idea that somebody has to be an attorney to submit a public records request on behalf of a group, or that we somehow have to incorporate or affiliate our groups for those to be valid legal groups. I think a loosely affiliated coalition of citizens is what this country was built on, and that's what democracy is about. So to say that this man right here and the other plaintiffs in this room today, that they don't have an interest in this, that this county doesn't have an interest in that, it's not right. It's not right, Your Honor.
Your Honor, if I could respond to that. As previously cited, the Audit Arizona clearly has no capacity, Your Honor. It is an unorganized entity, and it's an association that does not have the ability, the capacity to be a plaintiff. With respect to the other plaintiffs, Your Honor, the state or the defense feels that certainly if they would have come forward and taken any affirmative actions to make the record request on their own, then they couldn't be dismissed as plaintiffs, Your Honor. With the exception of Mr. Arellano, the other remaining 6 did absolutely nothing. And I made reference to that at the onset of today's hearing. If the defendants admitted every allegation in the complaint, Mr. Rojas has done nothing to make this request. Same for Plaintiff Parada, same with Plaintiff Scholnick, same with Plaintiff Matheson, same with Plaintiff Olgan, same with Plaintiff Valdez. The only thing Plaintiff Arellano Oros did was potentially help draft the letter, if his testimony is to be believed, and also tag along with Plaintiff Bracey when Mr. Bracey's signed written public record request was made, and then also potentially help draft emails or letters that followed Mr. Bracey's original request. So with respect to the nominal plaintiffs other than Mr. Arellano and Bracey, there should be no question in the court's mind that they have failed, that they should be dismissed. With respect to Mr. Arellano, it's a little closer call, but the state still feels that having Mr. Arellano present with him when the written request was delivered doesn't confer upon him a real party in interest. It could have been his accountant, it could have been his chauffeur, his golf caddy, it could have been anybody, but the fact remains there is no link between the records request made by Mr. Bracey and every other plaintiff with respect to the defendant. Thank you.
I'm not going to rule on that at this time, so you would continue and call your first witness, please.
Your Honor, at this time the state would also make a motion for a directed verdict according to Rule 50 of the Arizona Rules of Civil Procedure. If I may be heard briefly on that.
Yeah.
Your Honor, we've heard testimony today from Plaintiff Brakey that a records request was made on July 9th of this year. That request was in writing. We've also heard evidence that request was responded to by the county in Exhibit 6 on August 7th, 2014. We've heard testimony from the first expert from a system that was used by Pima County in 2007. And if this were 2007, and if this were Pima County, that might be instructive. But it's not, and it isn't. And that's the testimony that we heard from the first witness. He indicated at the very end of his testimony that he doesn't believe there's a problem, but he doesn't know. And again, this is based on 7-year-old information in a different county involving a system there's been no testimony regarding that system today. The second witness kind of echoed the same sentiments with a little bit more detail with respect to request number 10, indicating basically, that no system is foolproof as long as it's networked. Well, Your Honor, we haven't heard any testimony about whether or not the system is even networked. We don't know if we're using if the county is using a GEM 2.0 or a GEM 15 or a GEM 200. We have no idea what system is being used. That's point number one. Point number two, we have no information before us that there's been no evidence presented that the information requested is indeed a public record. There was some talk from the first expert that it may or may not be metadata, but whether or not it's metadata doesn't mean that it is necessarily whether or not it's metadata is still up for issue, Your Honor. And I know counsel at the beginning of today's proceedings quoted the definition of metadata and cited a case that metadata is public record. I would say that I would ask the court to take a look at that may be somewhat limited, and I would simply ask the court to find that at this point, up to this point, that the plaintiffs have simply failed to establish, number one, that the request was made, was a public record request, and number two, what the defendant has done to fail to comply with that, Your Honor.
Well, Your Honor, it's only designated as a public records request that half of all of the correspondence that's been.
Can you speak up, please?
Your Honor, it's only been designated as a public records request, about half the correspondence that's been submitted to this court. And again, the statutes don't prescribe a form for public records request, but even if they did, one would imagine that a letter laying out points of information that have been requested certainly qualifies as a public records request. They've also misrepresented the testimony today with regards to items 5 through 9. Testimony was not that items 5 through 9 would impair network security if it was linked to the internet. That wasn't the testimony at all. There was some discussion over item 10, but at least that wasn't my impression of what was said here today. And then with regard to the metadata, again, they severely misrepresented the testimony. There was an issue over one small piece of information, namely the dial-up modems numbers, whether that was metadata or data, and the expert came down and said that was data. With regard to the rest, I think everybody's been very clear that this is all metadata, and it certainly meets the definition in Lake versus State.
Anything else?
Your Honor, only that I believe it was only the first expert that addressed the metadata issue. I don't think the second expert or any other witnesses referenced the nature of the record request. I would direct the court's attention to Plaintiff's Exhibit 6, which is the responsive document from the county, and that indicates that it's a records request. It doesn't say public record request. It doesn't say pursuant to such and such a statute. I think that does reference the statute further on, but that's simply with respect to the county's obligations in Title 16. There's no reference to Title 39, and there's no admission from the county that what has been requested is indeed a public record request. Certainly nothing that we've heard today that the county has conceded that the records request has been made and that records request was a duly made public record request.
Thank you. Motion for directed verdict is denied.
Your Honor, the defense would ask that the court make a record of that as to why the motion was denied.